Welcome to Negotiating Author-Friendly Book Contracts, a virtual event part of the ISA's Research Support Series led by Michael Rodriguez, a licensing and scholarly communication strategist at LYRASIS. In today's webinar, Mr. Rodriguez will show you how to negotiate author-friendly book contracts and obtain the best possible deal from your publishers while tackling questions like how to understand the legalese and negotiate your contract to safeguard your rights as an author. And how can you negotiate better royalties, preserve your ability to reuse your own writings, and avoid putting yourself at legal risk? Questions are welcomed and tackled at the end of the presentation. You can drop them in the chat and we will read your query aloud. You can also use the raise hand motion at the bottom of your screen to ask a question yourself. Please note that we are monitoring the chat and that this webinar is being recorded for people to access in the future. If you want to know more about upcoming ISA's virtual program events, please visit the link in the chat box. I thank you again for attending and will now mute myself and become part of the audience.
Good morning, everyone, or good afternoon, depending on your time zone. I'm Michael Rodriguez, and I am your presenter today for the webinar on the topic of negotiating author-friendly book contracts. The webinar is a sequel to a webinar that I led in May 2022, and that webinar focused on negotiating author-friendly publication agreements with a focus on journal articles specifically. And coming out of that webinar, it became clear that there was an appetite among International Studies Association members for a webinar that looks specifically at book contracts, which can be a very different animal with very different considerations than a journal article publication agreement. So hence today's webinar. A bit about me, I am a licensing and scholarly communication strategist at LYRASIS, as Lauren shared. And prior to that, I was working at the University of Connecticut Library for 6 years as a licensing and acquisitions librarian and as a collection strategist. And in both of these roles, a huge part of my job was negotiating with publishers. The context of negotiation was mostly around providing research databases, journal packages, ebook collections, etc., to libraries for their faculty and students to use in research, but very much negotiating with publishers. And as a result of that experience, I began helping colleagues and clients negotiate their publication agreements and their book contracts, and developed a range of experience and knowledge in those areas. So a little bit about me, just to put myself in context of the topic today. So the first question I ask is, what is copyright? Because copyright is very much a foundation for book contracts. Copyright in the United States, but worldwide at this point, is a bundle of exclusive rights that are automatically granted to the creator of a work when that work is put into a fixed and tangible form. So exclusive rights, meaning these are rights exclusive to the creator of the work, unless they choose to give away those rights. They're automatically granted, so you don't have to necessarily register your work with the National Copyright Office or fill out a form somewhere. As soon as you put that work in writing, or you video record it, or find some other way of capturing it in a semi-permanent way, then that copyright is yours. It is not, as a concept, copyright is not applicable to facts, data, or ideas, but it is absolutely applicable to original expressions of those facts, data, or ideas. So in other words, let's say you have a raw set of data, of numerical data, let's say. That data is not copyrightable. However, if you create a table that displays and contextualizes that data for an audience, then that is an original work of authorship and is absolutely copyrightable. There are a lot of distinctions to be made here and in an international context between the different forms that copyright takes depending on your jurisdiction. So we often see differences between common and civil law, where you see European continental influence traditions versus Anglo-American, Australian influence traditions, where copyright is treated somewhat differently. But there is also a lot of global parity among how copyright is treated among various countries because of international treaties like the Berne Convention that pretty much every country in the world at this point is party to. So a big distinction here between the more Anglo versus European traditions of copyright is the distinction between economic and natural rights in copyright. So in the United States, in particular, copyright is seen very much as an economic incentive to encourage authors and creators and inventors to produce more copyrighted works that they can monetize and have exclusive control over that monetizing. The distinction here is with moral rights, which you tend to see more in European and civil law traditions, which is much more about the author as a creator and about retaining integrity over the work in question. So these will come into play as we start talking about book contracts. I mentioned earlier that copyright is a bundle of rights, and these are the rights that are bundled in that term. The right to reproduce a work, so making copies, the right to distribute the work or to share it more widely, the right to create derivatives of the work. So for example, prepare translations or turn a book into a chapter or vice versa. The right to perform a work, if it's a piece of music, for example, and a right to display the work. For example, if you're showing an image on your slides at a conference. There are a lot of statutory exceptions and limitations to these rights, such as fair use, that function to allow third parties to take some advantage of the work that you've created without seeking permission or paying royalties. But these are exceptions and limitations. The rights are yours exclusively for the most part. So why does copyright matter to you as an author? Many publishers will ask you to transfer or assign your copyright to them when you try to publish a book. The problem here, and this is why copyright matters, is that if you assign ownership of your book or any other work to a publisher, then you become what is called a legal stranger to your own work. You cease to have a controlling interest or ownership in that book or article or what have you. The publisher can choose to assign rights back to you, but the ownership of the work is now theirs. And the problem here is that publishers do not need to own copyright in order to publish your book. They need the equivalent of a license to publish, and we'll talk to you a little bit more about that in a few minutes. But you do not need to transfer your copyright to anyone in order to publish a book, or you shouldn't. So it's important for authors to think about what rights matter to them in the context of that particular book or other work, and either negotiate with the publisher to retain copyright or figure out what rights you care most about and ask the publisher to transfer those rights back to you. And this really boils down to knowing what you are about and what your goals are, and understanding what your publisher sees as important. So I phrase this here as know thyself and thy publisher, and knowing yourself is the most important part. So what is your situation as an author? And what are your goals in publishing this book? If you're on the tenure track, you're a year out from getting tenure and you really, really need to have your first book published, you may not worry that much about copyright transfers and these sorts of details because you have a very specific situation and timeline that you're working with. If, on the other hand, you're an established scholar or you're writing a book sort of on the side, a novel or a popular work of nonfiction, then maybe you can take the time to slow down and engage with the publisher around rights retention. So it really does depend on your situation and what your goals are in publishing. Is your goal to make money from sales of the book? There are plenty of authors out there who rely on their publications for living. That's not necessarily the case with faculty members. So revenue may be a secondary consideration for many of you. And quite frankly, in so many cases, even the best scholarship does not produce a lot of sales or a lot of royalties for authors. So maybe your big goal then is reputation. Maybe you want to publish your book with the best known and most respected university press out there. And other considerations sort of, again, maybe secondary. Or maybe you want to maximize your readership and publish a scholarly work with Belknap Press, for example, or some press that has popular reach and appeal. And depending what your goals are, you're going to be working with a different type of publisher. Oftentimes, you'll be working with a university press, with one of those smaller nonprofit publishers that have thin margins. And other times, you could be working with a large commercial publisher, like a Springer or an Elsevier, depending on your discipline. So these different types of publishers will have different business needs and profit margins, and they will have different types of expectations for their authors. Very often you'll find those large commercial presses will be very stringent in terms of what royalties they are willing to allow to authors, in terms of 20-page contracts that they ask you to sign. Whereas smaller nonprofit publishers may be a little bit more flexible, but also may not have the in-house legal expertise to negotiate with you in a meaningful way. They're also going to have different marketing and distribution abilities. So this will tie back into the readership component and really about how much you're expecting this book to sell and sort of targeting your negotiation strategies around that. So it really does come down to understanding what you're about and what your goals are, and then finding the right publisher to help you achieve those goals. So there are a couple of misconceptions, I think, around negotiation that I'd like to call out here and sort of talk through briefly. The first is that negotiating with publishers is just too much hassle to be worthwhile, that it's going to take hours and weeks of negotiation and emailing back and forth, and it's just too much hassle with everything else that the author has going on in their lives. And this is sometimes true. There are absolutely publishers who are going to be very stubborn, shall we say, about working with you and accommodating what you need. But there are also going to be publishers that will agree immediately to whatever you're asking for. So oftentimes it's a simple matter of preparing an email, stating what you need, and then seeing what the response from the publisher is, and sort of going from there. Sometimes it can take 10 minutes, other times it can take much longer. Another misconception is that you need to be a trained lawyer to negotiate these legal agreements. It helps, but it's absolutely not necessary. I do not have legal training, but I negotiate multi-million-dollar contracts with publishers all the time. So I think once you get a sense of what the documents look like and what kinds of language you see in those legal agreements, you'll be empowered and feel confident to go forth and have those conversations with the publishers. And that's what today's webinar is all about. The third misconception I often see is that publishers will refuse to publish my work if I try to negotiate, and that's simply not the case. By the point of negotiation, publishers will have accepted your book proposal, and they will have submitted, they will have sunk a lot of effort and time into working with you to publish that book. They're not going to suddenly refuse to publish your work if you send that email to open negotiations. There may be a situation where you just can't come to terms and you mutually agree to try a different venue for your work. But no publisher is going to dismiss that out of hand. Of all the experience I've had in this space, that has never happened, where a publisher just refuses to publish your work if you try to negotiate. And fourthly, a misconception is that there are no real repercussions for me if I do not negotiate my publication agreement. And this is I think, the most risky misperception, because if you do not negotiate your publication agreement, you become a legal stranger to that work that you've dedicated so much time and intellectual energy to developing, and you may be out money, you may be placed in a situation where you have to ask the publisher for permission to reuse your own work, to share it with your colleagues, or to assign it to your class, or to post a chapter online, or to rework parts of your book into an article. So there are definitely repercussions, and we'll talk a bit about how to avoid those. So when you enter into a situation of negotiation with a publisher, it's important to approach it with the right mindset, with a win-win mindset, where you're not entering into some sort of adversarial relationship with the publisher, but you're attempting to collaborate with the publisher to end up in a with an outcome that is mutually beneficial, where you get the rights to use your work as you see necessary, and the publisher gets to publish your book. So negotiating for the win-win is critical, and asking early and often is an important part of that. Again, the worst they can say is no if you ask. So definitely ask if you have concerns, if you have questions, articulate those once you get that author's agreement, and have that conversation with the editor or the publisher representative. Knowing your alternatives is important too. There's a great acronym in negotiation that's referred to as BATNA. So BATNA standing for Best Alternative to a Negotiated Agreement. And this basically is your understanding of what happens if you cannot come to terms with the publisher. Do you have the ability in your situation to find a different publisher, knowing that could take some time? Or are you really committed to this publisher and you just are trying to get the best deal you can while knowing that you're still going to go with this publisher regardless of the negotiation outcome? Because that's going to influence a lot of sort of what you're asking for and how you're framing your asks. Picking your battles is important too. What do you care about and how much do you care? So again, if you're a year out from getting tenure and you really need that first book, maybe you're less worried about the niceties of your rights as an author than someone who's maybe much more established in the field and has time to take a while with these negotiations. In some cases too, you may have produced a book that is an edited volume. So maybe you really care about the topic and you're very proud of the book, but you've maybe put less time or less intellectual energy and originality into that book. So you are more willing to be flexible with a publisher than you would be if the book was a single author monograph by yourself that you had sunk years of work into. So again, sort of weighing what your situation is. And then making a practical case for the publisher to accept what you're asking for. So if you can explain your reasoning, that's very helpful, because in many cases, the publisher representative that you're talking to isn't authorized to make a final decision. They have to take your requests and your rationale for those requests up the chain, potentially even talking to their legal department. So if you can just very succinctly outline why you're asking for what you are, that can be very helpful for your editor to then make the case internally. And this mentioning the editor here, I think, ties into a very important point as well, which is try to be a good partner. So like meet your deadlines, be responsive to email, etc., and build a positive working relationship with your editors so that when you do have this conversation about your rights as an author, your editors are more inclined to have your back with the editor-in-chief and with the publisher. So when you're actually conducting negotiations, there's a lot of different ways you can go about doing it. You can ask courteously via phone or email, explain what you want. And then oftentimes there's a back and forth with the editor or the publisher representative, which can vary in duration, but anywhere from 10 minutes to some hours of your time. And then when you're asking for something, what the publisher will do is give you typically a PDF copy of the author agreement. And what you can do is actually edit that agreement within Word or Adobe PDF. You can use the comments or track changes feature. You can ask to remove certain language and substitute your own. You can also mark it up by hand, particularly if you're mostly striking through things. And you can offer alternative language. Alternatively, you can simply ask for what you want in the form of an addendum, basically an amendment to the copyright, to the book contract that you attach to the main contract. And we'll talk a little bit more about these in a minute. So just a quick word about co-authors. If you're co-authoring a book, it's important to get on the same page with your co-authors early on. And if you're an editor of an edited volume, it's important to share what kind of contract the authors of chapters in that edited volume will be signing, just to get ahead of any concerns that may surface later in the process. As the editor or author, you're probably going to be signing the contract as an agent on behalf of your co-authors. So it's important, again, to sort of make sure your co-authors are on the same page and you get permission to sign on their behalf. And if you're not the primary author, communicating any concerns to that primary author, the corresponding author, sooner rather than later is important as well. Okay, so let's get to the meat of book contracts. So when you look at a book contract, what you typically see are these sections, not necessarily in this order, but generally book contracts will have the same elements. You'll grant rights to the author, to the publisher to publish your work. There will be expectations that the publisher states around what the manuscript should look like, when it should be delivered, and what format, etc. There'll be an agreement to publish, and there'll generally be some sort of signature block for you to sign. There'll be a statement of mutual obligations. So the publisher makes promises and guarantees to you, and you make promises and guarantees to the publisher. There'll be some sort of very legalistic section about what the promises are, and if the promises are broken, who is liable for what. There'll be a section addressing payments or royalties, and there's usually some sort of general provision section that talks about legalistic elements that don't fit nicely into any of these other sections. So first is the grant of rights. This grant of rights, again, this could be an assignment where you transfer copyright to the publisher, so the book will be published in the publisher's name. You could grant an exclusive license to the publisher while retaining copyright in your name. Or you could grant a non-exclusive license to the publisher, for example, to publish your work while you retain the right to take the book elsewhere after a certain point and publish it again, or post it online, or prepare translations or anything along those lines. So this really governs what the publisher can do and where and when and how. So if you assign your copyright to a publisher, you can ask for some rights to be licensed back to you. You can license some rights exclusively and others non-exclusively. So for example, you could assign exclusive rights to publish in English to a publisher, but assign, let's say, French translation rights to the publisher for a certain period of time, for let's say 5 years after publication, after which those translation rights become non-exclusive, and you can take that same book and translate it and publish a translation with a different publisher. So there's a lot of different ways you can work this depending on what's important to you. And you can also impose time limits on these licensed rights. So you can say 5 years, after which these rights become non-exclusive, and so on. So a couple things to watch out for, and I'll skip through a couple of these because we addressed them later. But when you're producing a work, publishing a book, and you agree to transfer your copyright, which is fine, make sure you're not inadvertently transferring your patent or other intellectual property rights. So read that grant of rights clause very carefully and make sure that the only rights you're transferring are your copyright, not your patent or your intellectual property rights in the processes that you're describing. Another important thing to look out for is a legal clause that's called the merger. Essentially what a merger clause means is that it excludes handshake deals. So if you make a verbal or an email agreement with an editor about some aspect of your book, as soon as you sign that license, and those as soon as you sign that book contract and and the terms that you agreed to verbally or via email, if they're not incorporated in that contract, they don't count legally. They're not enforceable legally. So just be aware of that. If they're very important elements that you've agreed to verbally with your editor, but are not in the contract, just be aware that whatever you agree to verbally is probably not going to be legally enforceable unless it's written in that contract. So this is really important aspect. So most researchers are very eager to retain the right to share their works with colleagues. So can I send around a PDF version of my book with the folks that I share a department with? Can I maybe post a chapter or two online, or give them to my students, or take a chapter and publish it in an edited volume somewhere, or present portions of it at conferences, or translate my book into another language if the publisher isn't willing to do that for me? So these are rights to reuse and share your work. And there's actually a really good language that was developed by City University of New York addressing this need, that you can copy and paste pretty much verbatim into your book contract. I'm including it on the screen here, and just as a reminder, the recording will be shared, so there's no need to frantically write this down. So important elements in book contracts. We're going to go through each of these as briefly as we can so that we can save some time for questions at the end. This question comes up a lot. So what happens if my book goes out of print? What happens if it's no longer being actively manufactured or sold by the publisher? In many cases, you can negotiate your contract so that if that happens, if your book goes out of print, all those rights revert back to you and copyright goes back to you. And then you can do what you want with the book. You can shop it around to another publisher, or you can just post it online free of charge for everyone in the world to read. And this is pretty standard practice for book contracts, but the language that goes into these standard provisions around rights reversion varies widely. So it's important to read the section carefully and make sure that it spells out the conditions under which rights revert to the author. So rights reversion typically has three elements. There's a triggering condition. So if a book drops below a certain number of sales or a certain like annual amount of royalties paid to the author, and if it drops below that threshold for, let's say, a 5-year period, that is the triggering condition under which this reversion activates. The contract should also spell out what steps need to happen after the trigger is met. So in many cases, the burden is on the author to write to the publisher and say, hey, I've noticed that sales have dropped below 5 books a year for the past 5 years. I would like to exercise my reversion of rights clause. That's called a written notice or written notification. And that's a critical step in rights reversion. It usually does not happen automatically because publishers, naturally enough, want to keep ownership of works, even if they're not actively selling them anymore. And there should also be in that reversion of rights provision some sort of explanation of any additional obligations that publisher and author have to meet before the reversion is completed. So this was a very easy sort of standard clause in the days of print-only books, right? But ebooks are a giant wild card now. Because theoretically, ebooks can be sold indefinitely, right? They don't need to be manufactured. Once they're created and put on the publisher's website, the publisher can just keep selling digital copies of those indefinitely without cost to themselves. So the definition of sort of when a book goes out of print can be very different now than it was 30 years ago. The rights reversion clause might never be triggered. As long as ebooks are being sold. So it's important in this case to address the role of ebooks if your book is being published electronically, and just make sure that your reversion of rights is tied to print sales and not to electronic sales, if you can do it. Competing works. This is another very, very common clause in book contracts. Publishers may include a non-compete clause in their contracts to protect their investments, right? They don't want you to write a book for them and then a year later turn around and write a similar book for a competing publisher in this space, particularly when you're talking about textbooks, which do compete directly for sales and often cover very similar topics in consistent ways. So here it's important to understand how the contract defines a competing work. Is this any book that I publish, or is it only a textbook published about 20th century relations between Britain and the Commonwealth? Because those are very different. Those have very different implications for you as an author. You don't want this competing works clause to tie your hands and prevent you from publishing your work elsewhere. The other thing you can negotiate on is how long that competing works clause lasts. It really should not be open-ended. It should expire after a certain period of time. And I would say 5 years is a very generous amount of time to allow publishers under this clause. And finally, if there's a disagreement between you and the publisher about what constitutes a competing work, who gets to decide that? Who makes the decision about whether a work could compete with your previous book or not? And so these are all things that should be spelled out in your book contract. And if they are not, they should be. And if they are, you should read that language carefully and see what you're committing yourself to for the next 5, 10, 20 years. The other thing to think about too, as you're reading that clause around competing works, is whether chapters and articles are excluded, are not considered competing works. Because you should absolutely still have the right to rework a chapter into an article or an edited volume elsewhere. Although it may be fair to say that you will not produce a second book similar to the first one. Future option to publish. This is pretty typical. It's a little bit silly at this point if you're not a James Patterson type bestseller, but a lot of publishers want the option but not the obligation to publish your next book if the first book is successful. So again, this is a clause that you'll want to read carefully and make sure that you're not committing yourself 100% to publishing your next book with this particular publisher, because that publisher may not meet your needs for that next book and for your goals around your second book or your third book or fourth book. So definitely take a look at that provision as well and see what works for you. Royalties. This is the big one, the one we've all been waiting for. Authors get paid through royalties typically, and royalties are usually calculated as a percentage of sales. So it's important to pay attention to how the publisher is determining sales as the basis for royalties. So the best deal for you as an author is royalties based on the book's gross sales at retail price. So this means you'll recoup the most from your book. The second typical way to calculate royalties is based on the publisher's net income from sales. So this is usually going to be a lower amount than gross sales at retail price, because publishers will often heavily discount books when they sell them. So if you go to Barnes & Noble, you'll see 30, 20%, 30% markdowns on many books, and that's pretty typical. So you want to be paid ideally based on sales at 100% of list price, rather than at 70% of list price or whatever lower price the publisher puts on a book in order to move it in stores. And the third way to calculate royalties is based on publishers' net profits after they deduct costs of publication and distribution. This is less than ideal, shall we say, because often publishers don't make gigantic margins on scholarly works. And quite typically, you'll find that scholarly works either break even, lose a tiny bit of money, or maybe get a 10% net profit, something like that. It really varies. But publisher net profits are generally pretty low. So you'll be talking about a much smaller amount of money if you're basing your royalties on the publisher's net profits. So all three of these models are okay. I've worked successfully with all of them, but your royalties should be calculated percentage-wise on a sliding scale. With model 3, your percentage should be much higher because you're talking about a much smaller amount of money. With model 2, they should be higher as well. The percentage should be higher as well because, again, it's based on a somewhat lower amount. And then model 1 is the most favorable to you because it's based on that retail price, which is really the highest price that the book is going to sell for. There's other considerations. We don't really have time to get into those right now, but royalties have lots of potential variables. Let's put it that way. Another way that authors are paid is through advances and honoraria. Advances are amounts of money that are paid to an author before the book is published. And usually those advances are deducted from whatever royalties the author ends up earning. So if you get a $100 advance and you end up making $200 of royalties, then you're only going to get a royalty check for $100 because that advance was applied to your royalty. So what you want to do generally is try to negotiate as high an advance as you can, because that may be most of the money that you'll see from publishing a scholarly book. You're not guaranteed a large amount of sales and royalties, so a decent advance is important, and your advance should be non-refundable. So once the publisher cuts that check to you, they should then be able to go back and reclaim that money if your book doesn't sell as well as they expected it to. Advances should be due within 60 days of your delivering the manuscript or signing the contract. A lot of times you'll deliver a manuscript and the publisher 2 years later will still not have published it. So it's important to try to get those advances as soon as possible so you're not waiting around for your money. And so that the fact that that advance was paid and is non-refundable should hopefully incentivize the publisher to publish your work sooner rather than later. Where we usually see honoraria is in the context of when you write an encyclopedia article or a book chapter. I've been paid honoraria for these. And it's usually a set amount, or it's based on the number of words in that article or chapter. You should be getting at least 15 cents a word, whether that's calculated as a flat sum or actually calculated word by word. It should work out to around 15 cents. That's like the low end of industry standard for honoraria and fees. Particularly if you're writing a popular article or that's going to be published in a trade magazine or something along those lines. And if you're writing a chapter for a mainstream textbook, you really should be asking for money. I mean, if you're writing a chapter for like an undergraduate textbook that's probably going to sell hundreds of copies for a high price, you really should be asking for some form of compensation from the publisher for that. You're doing yourself a disservice if you're not. Whether that is royalties or whether that's like a one-time payment, definitely ask for compensation if you're invited to contribute a chapter to a textbook. And look at other compensation as well. So yes, royalties are great and honoraria is great and cash is great, but can you get a certain number of free copies of the book after it's published? Can you get a discount if you want to buy more copies? Can you get an electronic version of your book that you can keep and share more conveniently than handing around the print volume? So like, can you get a PDF? And can you work with the publisher to cover any costs that come with publishing the work, like getting licensing fees for any third-party pictures or illustrations that you've included? Try to work with the publishers so that they are responsible for the costs of producing your book and so that you are not responsible for that. Publishers tend to have deeper pockets than researchers. Subsidiary rights are also a common thing. So this is typically in relation to different formats that your work could be published in. So ebook format, audiobook, anything along those lines. So this is something that you can absolutely negotiate, and you can give the publisher the right to publish your work in hardback and paperback, but maybe you hold back the right to translate it or the right to turn it into a movie. Author liability is a significant element here as well. So a lot of times book contracts will put all the liability on an author if there is any allegation of copyright infringement or plagiarism or libel or breach of privacy. And that's problematic because most publishers have media liability insurance and authors don't. If there is a successful lawsuit, generally a publisher's insurance policy will kick in and cover their costs. So they should be going to you to pay the costs of lawsuits, however unlikely those may be. So what you'll want to do is say that interject qualifiers into the contract and say, like, to the best of the author's knowledge, there is no copyright infringement, something along those lines. And you want to make very sure that if you do accept any liability in the event of litigation, that you are responsible only if you knowingly broke your promises to the publisher, and you're not responsible for unfounded lawsuits that get thrown out in court but still involve lawyers' fees, for example. Satisfactory manuscript. So this is important as well. The contract should spell out elements like word count, delivery dates, anything along those lines, so that both you and the publisher are on the same page from day one about what constitutes an satisfactory manuscript. You should also look at making sure that the contract spells out who is responsible for things like creating the index or obtaining permission to reproduce illustrations in the book, copy editing, anything along those lines. You should make sure that you have the right to review any changes to the manuscript before it goes to press. You don't want publishers inadvertently changing your meaning or rearranging your writing. You can ask for to be consulted on things like book design, cover, and title. Publishers are going to do what the publisher is going to do in order to make what they think is a marketable book. But it would be great if you're consulted at least, and that's something that you can absolutely put into your contract. Also include a deadline for publication. Publishers have been known to sit on books for years without publishing them. And if you're working, again, on that tenure track and you have a timeline and you need to get that book published, then it's very important that you include a deadline for publication in the contract. And if the publisher fails to meet that deadline, then the rights revert back to you, and you can shop around that manuscript to another publisher who may publish it more expeditiously. So I did pull together a couple of sample exercises, and these will be shared with you in the slide. It's when the recording's distributed afterward. But I did want to show you an example of a Duke University Press publication agreement. This is specifically for book chapters, but it is actually quite applicable to monographs as well. So this is a very short contract. You'll usually see 20-page contracts rather than one-pagers, but this is fairly representative of what you'll see. So assignment of rights, the author makes all these promises to the publisher and accepts some degree of liability for breaching those promises, for breaking those promises. And then the publisher assigns some rights back to the author to use the work for non-commercial purposes like teaching or quoting or photocopying and so on. And this section addresses some of those mutual obligations around the publisher agrees to provide proofs prior to publication to the author. This language here, Duke, that's problematic. The author agrees to reimburse the publisher for costs of modifying or improving the illustrations or anything along those lines. So even with this very short contract, you can see that it's a solid basis to operate from, but there's a lot of small things that could be changed in order to maximize your rights as an author and make sure that you have the right to reuse this work and that you're protected from legal jeopardy to the extent possible. So this, I think, is the most valuable resource out there for anyone who is working on a book contract, for any author working on a book contract. This was a book that was produced by the Authors Alliance, which is a group of authors that came together to to prepare this, these guidelines for other authors. So negotiating and understanding book publication contracts. This is a book that's freely available online, and it covers everything that I covered today, but it also drills down into more depth and gives you lots of examples of sample language that you can copy and paste into your own book contracts to address issues like liability and other concerns that you may have. So this is a fantastic resource. The Authors Guild is another group that's created a model trade book contract. So this is really designed for like trade books and popular publications, but it's a model contract that gives sort of author-friendly language. And you can essentially fill this out and give it to the publisher to sign. You can pull language from it to copy into your own contract. And you'll see that it's divided very helpfully into sections that are very similar to what to how I structured the presentation today. So it's great for sort of walking you through section by section through this contract. And through these common sections of a contract, particularly for folks that that these agreements are new for. And here are some additional resources that might be helpful for you as you venture into negotiating your contract. There's a couple of web pages up top that address copyright. There are 4 resources that I find very helpful around book contracts specifically, including links to the Authors Alliance and the Authors Guild publications that I mentioned. And there's also a couple of resources down here specifically around negotiation, including a book that I found super helpful in sort of getting into the mindset of negotiating with anyone, with a publisher, but negotiation in really any context. So I'm happy to take any questions now. I'm going to take a quick look at the chat and read out any questions I see. I'll also check the Q&A. But you can also feel free to contact me anytime. My email address is on the screen. So feel free to shoot me an email if you have any specific questions about book contracts or negotiation or copyright. I'm happy to take those questions now or in writing at any point in future. So let me take a quick look at the Q&A. We have one anonymous question. So what compensation, if any, should be expected for an edited volume that you contribute a chapter to? I think the answer to that is really going to vary depending on what type of edited volume is in question. So if it's a textbook, for example, designed for a graduate or undergraduate students, the expected sales of that textbook are probably going to be high enough to justify you're getting some compensation. So I would say you could get a one-time honoraria. I would say probably $500 minimum would be appropriate. You could also get a percentage of the overall royalties that the editor of that edited volume is getting. I recently published a chapter in a textbook where the editor was getting, the usual 15–20% of royalties, but they very kindly shared those royalties equitably with all the contributors to the edited volume. So I ended up getting like 1% royalties, which wasn't fantastic, but because this was a textbook, the royalties were actually pretty decent. For a scholarly work. There's another anonymous question. So how much of the research and writing should be done in advance of contacting the publisher? So what's the ideal point to negotiate a contract? That's a great question. I would say definitely have your book proposal accepted before you start worrying about contracts. I would ask probably for the author agreement early on so you can see what you're going to be working with. And then depending on when in the process the publisher wants to sign a book contract with you, that would be the time to negotiate. Typically, they'll want a contract before you deliver the manuscript and not after. So probably sooner rather than later in the process would be good. Although I have seen a lot of those really detailed negotiations happen after the manuscript is delivered, when both parties at that point have been fully invested in publishing this book. So in a lot of ways, your leverage is actually increased if you're doing those negotiations a bit later in the process. But definitely ask for the standard contract early on in the process so you know what you're working with. So when and how should I negotiate e-copy for the book? So that's a great question. So generally, negotiate that as part of your book contract, wherever in the process that is. So if the publisher wants to publish your book as an ebook in addition to a print book, make sure that they share those details with you in the book contract, and make sure that you get a free copy of that ebook as well, because that's great to have around. You can share it with your colleagues and your students and so on. So that's important to get, and make sure that your ebook royalties are spelled out as well, because a lot of times ebook royalties should be higher than print book royalties, because the cost of selling and distributing ebooks is so much lower for publishers as opposed to printing and sending out all these print volumes. So let me try to answer your question, Dimitri. So the question is, have you come across advance contracts after a publisher has read sample chapters in a book proposal and offers an advance rather than firm contract, binding authors to publisher but not publisher to author? How common are those, and how realistic is it to negotiate a firm book contract with university presses based on a book proposal and sample chapters? So that is an excellent question, and the answer is, I guess, always that it varies. But I do think that it's definitely realistic, given the competition around getting published with some of these presses, to get a little bit more of a nebulous commitment from a publisher early on in the process before they've seen the final manuscript. So I think in that case, what you probably want to do is have some sort of abbreviated version of a contract that you both sign, where the publisher commits to a non-refundable advance, where the manuscript specifications are spelled out, where a deadline to publish is spelled out, sort of all of those important early elements. And try to get as much of that in writing as you can early in the process, even if you're not negotiating a fully fledged book contract at that phase. So definitely try to negotiate like that preliminary contract as part of the publisher's initial commitment to publish your work. Great question. So we have another question here. Yes, let's see. So the person asking the question has negotiated a contract for a textbook with a certain publisher and transferred them the full copyright. And the actual book contract language says that the author authorizes the publisher to register the copyright in the work and/or any revision or other edition thereof throughout the world in the name of the publisher. The publisher shall have the right to renew such copyrights if the publisher deems it advisable. Yeah, I mean, I think that's certainly less than ideal, particularly in the context. It's okay to transfer copyright to the publisher. It's not ideal, but it's common practice. But I think in that case, the publisher should register the copyright in your name and then have an exclusive license to publish the book if they need that. It's effectively the same as transferring ownership of the book. Granting an exclusive license to publish a work is effectively the same as transferring ownership. But at least it preserves your moral rights, right? Your right to be attributed as the author of that work, and to have your name appear in the copyright registration. So yeah, I think that could be a fairly minor tweak in future book contracts of just say, okay, so fine with transferring the copyright, but register the copyright in my name and not in the publisher's name. And then you can always do any carve outs as needed if you want to keep some translation or reusage rights for yourself. Great question. So there's also a question about, could you please let us know what we should look at when negotiating for open access? I am so glad you asked that question. So when you publish a book on an open access basis, it's generally going to be under a Creative Commons license, what is called an open license. And those open access publication agreements are, in a lot of ways, they're similar to traditional agreements in terms of like author liability and manuscript specifications and all of those elements. But you don't have to worry about copyright in that case as much, because generally, when you publish a book open access, you'll automatically, you and everyone else in the world will have the right to reuse that work, to republish it, to prepare derivatives, to share it with colleagues, and so on. So publishing on an open access basis removes a lot of the concerns that authors often have around how they're allowed to use the work after its publication. So that's definitely, so publishing open access is actually, in most cases, a really positive direction when you're working with book contracts, because it removes a lot of those concerns. It obviates a lot of those concerns. Okay, so we have a few more questions. For an edited volume of an academic book with 12 chapters, my assumption is that everyone at least gets a copy of the book. Again, what about e-copy rights? Yes, so I mean, it is pretty standard practice that if you're contributing a chapter to an edited volume, every one of those contributors gets a complimentary copy of the print book. And in my experience, you will generally get a electronic copy of the chapter that you contributed, although you may have to ask for it. So I would say in that case, you definitely include just like a single line in your book contract saying that all contributors to this edited volume will receive a electronic copy of the entire book in PDF format. Keep it open and shut. Doesn't need to be super elaborate, but just state that everybody gets an ebook version and the format in which that ebook version will be received, because you don't want to get it in some really rigid lockdown format that you can't share, or that in a software format that deprecates over time and you won't be able to open it in a few years. So generally ask for the book in a EPUB or PDF format, and just include that requirement in your book contract, and publishers get it. Like that won't be controversial in 95% of cases. It's a very reasonable ask. Great. Yeah, thank you. I'm very glad this has been an informative session. And again, please feel free to reach out to me at any time. If you have any specific questions, if you're entering a particularly hairy negotiation, or you're looking at a 20-page book contract for the first time and you're not sure where to begin, I'm very happy to help out with any of those questions.
Excellent. Thank you so much for sharing your knowledge, Michael. I particularly learned a lot through this session, specifically what you were talking about, the misconceptions about negotiating, the clarification about, copyrights and patents, the role of ebooks, because now information is available digitally. So how do we manage that? And I also like that you took the time to share some additional resources with us so that we can see how different, publication houses deal with agreements and contracts for publication.
Thank you so much, everyone. And I hope this was informative and helpful. And I did just put my my personal email into chat. So if you have any questions now or in future, you'll have that handy.